and not infant, and to require a person-appointed guardian to be a citizen of Uganda as required in the Children Act. Secondly, completeness to make provision for the court to appoint a guardian where any of the persons with priority are not eligible for appointment.
Now, honour members, last time we had bring the Administrator General's Act, we had occasion to deal with this matter. The word infant is not there by accident. An infant could be a child, but child is not necessarily an infant. In law, the infant is someone who needs care, who has no capacity to contract, who needs a guardian. That's why the word infant is there. It's not by accident. You cannot remove the word infant. You cannot.
Maybe what we shall do, according to the chair of the committee, maybe we shall go again back to interpretation section. Infant, if you're talking of a child, I am sure if you have a mother now, even if you are 100 years, the mother calls you he calls you her child. So a child is a child, but an infant is different. Somebody with an infant is who needs serious help, who cannot do anything on his or her own. So we cannot delete infant. Maybe we can say infant stroke child according to the, I don't know what, but the old law is very clear. It says infant. So I wanted to ask the chair, why are we deleting infant from the old law? Yeah. What problem has it got? Which they call it, according to the statutory guardians under section 44.
Madam Speaker, in this case, I would propose we replace the word infant with minor to create a clear distinction pertaining to age. Not every child is a minor.
I wish you could just leave the word as it is. Yes, Honorable Katonto.
Madam Chair, you see, you don't have to be ambiguous. What you already do, you define who a minor is and who an infant is in the definition section. And there would be no controversy on matters of age or what you want to mean. So if you want some clarity, then we go back and define who a minor or an infant is.
The minor is also an infant. You know,
you just define it. Chair?
You are dealing with succession. You are dealing with guardianship. A guardian cannot be appointed for someone who is a minor, who is an infant. You can't have a guardian for someone who's 20. It's not by accident. Yes.
Madam Chair, the Right Honorable Chair, the way forward is that with your wealth of experience in that chair and the guidance you're giving, we want to boldly say that we want to adopt the infant to be used, and because there is no infant who is not a child, but you can have a child in the succession law here who is not an infant. So I absolutely, yes, so I absolutely agree with that guidance, and if you can go ahead on that.
We'll leave the word infant there. Then we amend paragraph B, C, D as proposed. I put the question that the rest of those C, B, C, D, and E be amended as proposed. Those in favor say aye, the contrary no. Ayes have it.
And
Clause 21
right.
amended.
So the question of clause 21 as amended do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it. You have a new clause?
Yes, Right Honorable Chair, we have an insertion of a new clause in the bill immediately after clause 21. Customary guardian as the heading. 1, family members of a child may appoint, and I think some will be consequential amendments where the child appears, may appoint a guardian of a child in accordance with their customs, culture, or tradition, where A, both parents of the child are dead or cannot be found. B, the surviving parent of a child is incapable of being a guardian or ineligible of being appointed a guardian. Or C, the child has no guardian or any other person having parental responsibility over him or her. 2, for the purposes of this section, customary guardianship means having parental responsibility of a Ugandan child by a Ugandan citizen resident in Uganda in accordance with the customs, culture, or tradition of an indigenous community in Uganda. Justification: to make provisions for the appointment of a customary guardian of a child by a family in accordance with the customs, culture, and tradition of an indigenous community in Uganda. And for further clarity, an indigenous community in Uganda is taken the word right from our constitution, the schedule, where others who do not know, they may say tribe. But for example, if you come from Bugweri, you cannot be a customary guardian in West Budam for reasons that you do not know what Kalo, how we do things there. So that's just to help Honorable Katuntu to appreciate.
Structure of this provision would imply that it was on the presumption that the word child had now been adopted instead of infant. Isn't it? Honorable Chair, does this presuppose that the word infant had been substituted by child in the previous provision?
Yes, Right Honorable Chair, that we would have to use that now that we've adopted the word infant instead of a child, that would go as a consequential amendment throughout in regard to this bill.
Okay, now members, the word infant be substituted to the word child in the proposal. Put the question that a new clause be introduced as proposed. Those in favor say aye, the contrary no. I submit.
The new clause as amended.
Put the question that new clause as amended do stand part of the bill. Those in favor say aye, the contrary no. I submit.
Clause 22.
22, Honorable Chair.
Clause 22, insertion of a new section 44A in Principal Act. The proposed section 44A is amended. A, in the proposed subsection 1 by deleting the words appointed under section 43. B, by inserting the following new subsection immediately after the proposed subsection 2 and renumbering the provision accordingly. 3, a person shall be eligible for appointment as a guardian in subsection 2 if he or she is above 18 years of age and is a citizen of Uganda. 4, a person appointed under subsection 2 shall, before taking up guardianship of an infant, apply to court to confirm or reject the guardianship. Justification: the proposal to amend the proposed section 1, subsection 1 is to expand the provision to apply to all circumstances where a person is appointed in the act and not to limit it to appointments made in section 43. Further, the prescription of qualification is to comply with part 6A of the Children's Act on qualification of a guardian. Lastly, on that, the proposal to require a person appointed guardian by another guardian to apply to court is to prevent the provision from being abused and to comply with the appointment of a guardian under part 6A of the Children's Act.
No members, put the question that a new clause be inserted as proposed. Those in favor say aye, the contrary no. Ayes have it.
Clause 22 as amended, 21 as amended. It's
I think
22,
of the new one.
22
It's a new
as
one.
amended.
With the question of clause 22 as amended, do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 23.
Honorable Chair, 23.
Clause 23, amendment of section 45 of the Principal Act. For clause 23, there is substituted the following. Replacement of section 45 of the Principal Act. The Principal Act is amended by substituting for section 45 the following. 45, the heading, head note is power of the court to remove a guardian. 1, a person may apply to the High Court to remove a guardian appointed under this act. 2, court may only remove a guardian where it is satisfied that A, it is in the best interest of the infant to remove the guardian. B, the guardian has failed, refused, or neglected to act as a guardian. C, the guardian has neglected his responsibilities as a guardian. D, the guardian has not complied with the conditions of the guardianship. E, the guardianship was obtained by fraud or misrepresentation. 3, court shall, upon issuing an order for the removal of a guardian, appoint another person to act as a guardian of the infant. Justification to comply with the grounds for removal of a guardian under the Children's Act. And 2, to specify which court may remove a guardian.
Members, the question is, yes, Lord Mendes.
Madam Chair, the old law was talking of grade 3 magistrates who have been removed. But it was saying that if it is certified that it is for the welfare of the infant. Now, why all these words? I would suggest that we maintain the welfare, because basically the welfare of the infant is food, clothing, shelter, school, whatever. Why are we changing? Why? What is best interest? How does an infant determine what is the best interest? So it should be basically what affects the infant, but the infant cannot know what is best to him or her. My proposal would be we maintain the word for the welfare of the infant.
Honourable members, the issue of the best interest is a test the court uses to determine whether you're qualified. It's not the child, it's the court which determines. Put the question that clause 23 be amended as proposed. Those in favor say aye, the contrary no. Ayes have it.
Clause 23 as amended.
Question that clause 23 as amended do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 24.
24, Honourable Chair.
Clause 24, replacement of section 46 of the Principal Act. In clause 24, substitute for the proposed subsection for proposed section 46 with the following. 46, the head note, powers and duties of a guardian. 1, a guardian appointed in this act shall be the personal representative of the infant for the purposes of managing the infant's share in the estate of a deceased person. 2, a guardian shall apply to court to exercise any of the following powers and duties. A, to have custody of the infant. B, to administer the property of the infant. C, to receive, recover, or invest the property of the infant. And D, to dispose of the property of the infant. 3, a guardian shall take all reasonable steps to safeguard the property of the infant from loss or damage, and shall annually account in respect of the infant's property to the surviving parent, court, or custodian of the infant, or to any other person as the court may direct. 4, a guardian who misappropriates the property of an infant commits an offense and is liable upon conviction to imprisonment for a term not exceeding 5 years, or to a fine not exceeding 150 current points. 5, a guardian who misappropriates the property of an infant shall, in addition to the punishment in subsection 4, make good the loss occasioned to the infant. Justification for completeness to ensure that the provision applies to all guardians appointed under this act, under the act. Two, to specify the duties and functions of a guardian. Thirdly, to ensure prudent administration of the property of an infant by appointing the guardian a personal representative of the infant, requiring the guardian to account for the property of the infant. And if he or she misapplies that property, he or she makes good the loss occasion and may also face criminal sanctions. I beg to move.
Members, question is that clause 24 be amended as proposed. Those in favor say aye, the contrary no. Ayes have it.
Clause 24 as amended.
Put the question that clause 24 as amended do stand part of the bill. Those in favor say aye, the contrary no. Ayes
Clause
have it.
25.
Next,
We would like to insert, we propose to insert the following new clause immediately after clause 24. Insertion of section 46A and section 46B in Principal Act. The Principal Act is amended by inserting immediately after section 46 the following new sections. 46A, terminology of guardianship, termination of guardianship. That's why it's good for you to sit next. Yeah. The guardianship, the guardianship of an infant shall automatically terminate upon the occurrence of any of the following circumstances, whichever occurs first. A, the death of an infant, the death of infant. B, the death of the guardian. Or C, upon the infant turning 18 years. 2, when guardianship terminates, all the property which the guardian administered shall in case of termination under subsection 1A, vest in the surviving parent of the infant, if any, or in the administrator of the estate of the deceased infant. B, in the case of termination under subsection 1B, invest in the surviving parent of the child, if any, or the infant until a new guardian is appointed. Or in C, in the case of termination under subsection 1C, vest in the infant. 46B, application of Cap 59 to guardianship under this act. 1, Part 6A of the Children Act shall apply to the grant, revocation, and exercise of the powers of a guardian appointed under this act. 2, where any provision of this act conflicts with a provision in the Children Act in regard to the appointment, revocation, and exercise of powers of a guardian under this act, the provisions of the Children Act shall take precedence over the provision of this act and shall in such circumstance apply. Justification for completeness to provide for the termination of guardianship of an infant, to harmonize the provision of this act with those of the Children's Act in regard to the appointment and operation of a guardian.
members, the question is that a new clause be introduced as proposed. Those in favor say aye, the contrary no.
Aye.
Ayes have it.
Clause 25.
Clause 25.
Clause 25, replacement of section 47 of the Principal Act. In the proposed amendment to section 47, replace the word importunity with abuse of position of trust, abuse of position of vulnerability. Justification to expand the provision to ensure that a will obtained by abuse of position of trust or vulnerability are also void. Finally, on that, to use simple words. And yes,
Okay, honourable members, put the question that clause 25 be amended as proposed. Those in favor say aye, the contrary no. I submit.
Clause 25 as amended.
Put the question that clause 25 as amended do stand part of the bill. Those in favor say aye, the contrary no. I submit.
Clause 26.
that
No, there's a new clause.
before 26, right, Honorable Chair, have an insertion of new clauses immediately after clause 26, 25. Immediately after 25, we would propose to insert the following new clauses. Amendment of section 50 of the Principal Act. Section 50 of the Principal Act is amended in paragraph C by inserting immediately after the words, each of the witnesses must, comma, the words in the presence of the testator, write his or her name and address on the last page of the will. And replacement of section 54 of Principal Act. The Principal Act is amended by substituting for section 54 the following. 54, effect of gift to attesting witnesses. A will shall not be considered as insufficiently attested by reason of any benefit given by the will, either by way of bequest or by way of appointment to any person attesting it, or to his or her spouse, and the bequest or appointment shall not be void so far as concerns the person so attesting, or the spouse of that person, or any person claiming under either of them where the will A meets the requirements of section 50C, and B would be sufficiently attested if the signature of that person who attests is not included in the number of the required under section 50C. 2, a legate and a will shall not lose his or her legacy by attesting a codicil which confirms the will. 3, where a will is handwritten or produced in a typed format on the instruction of the testator by a person other than the testator, and that person who writes or produces the will has a benefit given by the will, either by way of a bequest or by way of appointment, the bequest or appointment shall be void so far as concerns the person who wrote or produced the will, or the spouse of that person, or any other person who would claim under that person, or under the spouse of that person. 4, subsection 3 shall not apply to the surviving spouse, lineal descendants, or dependent relatives of the testator, where the will meets the requirement of section 50C. Justification in section 50 to make an addition to the legal requirements of making a will that is valid in law by requiring for each of the witnesses to write his or her name and address on the last page of a will in order to ensure easy authentication of the persons who witnessed the will. In addition, in section 54, to ensure that a person who witnesses a will is not unreasonably precluded from getting a benefit under the will of the other signatures, or under the will, if the other signatures are sufficient to prove the authenticity of a will as required in section 50. The proposal to bar persons presenting handwritten or typed wills from benefiting from the will presented by any other person other than the testator is intended to ensure the authenticity and validity of such a will is not questionable and to ensure that there is no conflict of interest in proving such wills. Finally, on this, to adopt the proposal made in clause 20 and 21 of the 2019 Succession Amendment Bill. I beg to move.
Honourable members, question is that a new clause being
Madam
inserted.
Speaker,
Yes, Honourable.
yes, we harmonized and I do not wish to appear to be departing, but there is a matter that I believe will create a problem. My senior colleague in presentation says the last page of the will, that the witnesses sign on the last page of the will. I would wish that we replace that with all pages of the will. My justification being that there is a possibility of forging the rest of the will and attaching what you consider the signed last page. On the other side, there is a fear that if we say all pages of the will and one page is skipped, then we open up the will for being thrown out. But my understanding is that the will has to be authenticated, and signing or attesting on each and every page would be the best in the circumstances to avoid forgeries.
What's your view on that one?
Thank you very much. That's one of the things which I wanted to raise, that each page of the will must be signed. But the other one which I'm getting perturbed is where you say, maybe I'll need clarification from the chairman of the committee. Supposing I have made my will with all these signatures, is there a conflict with it as far as the earlier clause where you said there should be enough for family members like a spouse, like the children, the dependents? If we have made such will it have a problem in, I think, let me remember the clause we passed. I think clause where you said we must leave enough. The new clause, the new clause, which was before clause 19. If I have my will properly written, attested to it, ready for when I go, it is ready. Will it have will it be in conflict if I don't consider clause, the new clause which was inserted before clause 19?
Honourable Chair.
Thank you very much. Madam Chairperson, the principal signatory to the will is dead. That's when the will becomes relevant. The only other people who can testify to that, the contents of that document, are the witnesses. It is only possible to testify on a document which you have signed. If, for example, this will was 10 pages, it may not be possible for you to remember each and everything in the 9 pages. The only way you can remember is by actually endorsing your signatures and particulars and say, yes, that is the content of the document I signed. So having the signature only on the last page endangers that will. So I want to agree with the learned Attorney General that actually because this is a unique document, colleagues. We are talking about a document whose author has died. It is not like an ordinary contract where even the parties could be alive to testify on what they wished. And sometimes, Madam Chairperson, the people who witness, they witness, but they don't indulge in reading the contents of the will, because that is acceptable. You go and witness each page without you even knowing the contents, so long as the author is there to say, can you witness this for me? So I think it is of paramount importance that we share, that we adopt the wisdom of the learned Attorney General, that we sign each and every page. The other question raised by the Honorable Fabi, Mr. Chairman, carry on cross.
Well, thank you, Honorable Katuntu, who was the chair of this committee, the longest serving member of this committee. And of course, the Honorable Nandala's question is taking us back to the clauses that we passed. The clauses that we passed sets the principle. Here now we are on other, how this, the effectiveness, the authenticity we are providing for the will as, now the principle of who benefits from the will, we've moved from that. Now we are on what constitutes a will. We cannot now talk about whether this is now invalidating what we've said before. This is about what constitutes a valid will. And I want to concede that to the wisdom of the Attorney General, the Land Attorney General, actually this one just bypassed our minds. But even the committee reports these days, we endorse every page. This original position was when people were still very honest. That has changed. Yes, thank you.
Honorable member, the new clause be amended as proposed by the Attorney General. Those in favor say aye, the contrary no.
The new clause as amended.
With the question that new clause as amended do stand part of the bill. Those in favor say aye, the contrary no. Let's have
Clause
it.
26.
With the question that clause 26 do stand part of the bill. Those in favor say aye, the contrary no. Let's have it. Honourable members, I think it's an appropriate time to adjourn. Can we move the House to resume?
Motion for the House to resume. Motion for the House to resume.
Honourable Rosette?
Right Honorable Speaker, I move that the House do resume and the Committee of the whole House reports thereto. I beg to move.
Honourable members, the question is that the House do resume and the Committee of the whole House report thereto. Those in favor say aye, the contrary no.
Report from the Committee of the whole House.
Right Honorable Speaker, I beg to report that the Committee of the whole House has considered the bill entitled the Succession Amendment Bill 2018 and has passed it as follows. Clauses that have been passed without amendment: Clause 3, Clause 4, Clause 5, Clause 8, Clause 10, Clause 17, Clause 20, and Clause 26. And the following clauses, there have been insertions in the following clauses: Clause 18, Clause 16, Clause 11, Clause 21,
You report that a number of new clauses have been inserted.
Right, Honorable Speaker?
You report that a number of new clauses were inserted. Just say 5 or 6. The numbering will change depending on the those people. Because you are not amending the preceding clause, you are introducing new one after. So don't number them.
Thank you, Right Honorable Speaker, for your guidance. So the Committee of the Whole House has inserted a number of in the number of clauses, and also some clauses have been amended. The amended clauses are clause 6, clause 7, clause 12, clause 13, clause 14, clause 15, clause 16, 18, 19, clause 21, clause 22, clause 23, clause 24, and clause 25. Also, some clauses have been deleted, clause 9 and clause 11. I beg to submit. Right,
Motion,
Honorable Speaker.
motion for adoption of the report from the Committee of the Whole House.
Motion for adoption.
Right, Honorable Speaker, I beg to move that the report of the Committee of the Whole House be adopted. I beg to move.
Honourable members, with the question that the report of the Committee of the Whole House be adopted. Those in favor say aye, the contrary no. Please submit. Members, I want to thank you for the work done today. House will resume tomorrow at 2 p.m. Thank you.